Good afternoon. I would like to welcome everyone to our Board of Zoning Adjustment meeting for July 22nd. We need 3 for quorum, so we're ready to go. So first on the agenda, let's stand and repeat the Pledge of Allegiance with me, please. Our item on tonight's agenda, we tabled from our last meeting. It was BOA 2021-08, consideration and action on the request for a 25-foot variance to the 75-foot stream corridor east setback for lot Hudson Oaks at Wolf Creek. Hidden Oaks is Oak West. I can talk. Hidden Oaks at Wolf Creek. Presenters Felix.
Madam Chair, Steve Burton's going to be presenting in Felix's stead.
What?
Steve Burton is going to be presenting in Felix's behalf.
Sorry, I'm not Felix, but I'll try my best here. Good afternoon, board members. As was mentioned, this item was previously tabled. This is a request to receive a 25-foot variance to the 75-foot stream corridor setback in the Wolf Creek area. Just to remind everybody, the last time this meeting was heard on July 8th, the Board of Adjustment unanimously tabled the item, and it was for 2 reasons. One, it said the item will be tabled until the applicant can, 1, reevaluate the self-imposed hardship aspects and come back to the board with a site plan that would more closely conform with the sensitive lands ordinance. 2, the revised site plan should also show the driveway location and how it is connected to the home. So we've got a revised submittal that I'll show you here on the screen. All right, I'm going to toggle a little bit here just to show you the differences. Here's what was originally submitted. And I can zoom in a little bit. So you had this, and last time this was being considered, I think there was some thoughts about seeing how far this building can be pushed to the front lot line there. And so what was submitted after that is the applicant did push their building up and closer to that front lot line, but the building didn't actually change in size. So the request is still the same. The patio is back here. It's still going to be 50 feet from the high water mark. So still within the buildable area on the subdivision plat, but in pushing that forward, the applicant did need to reserve a little bit of area for a driveway. And they are showing that driveway area, not really a huge driveway at all. But if this mouse will let me, I'll just kind of show you again. So here's what was the original proposal. And now here's what's being proposed. Still with a 50-foot setback, as pushing the building forward didn't really change because of the direction of the home. Something to consider as you look at this on the subdivision plat. Actually, this last page to show. On the subdivision plat, there's 25 feet on the neighbor to the south on their property, where the owner has to use that as an access. And so I think that's something that the board wanted to see as well, just how that access affects this lot. If I go back up to what's being proposed now, you can see the it doesn't come in at like a normal building would that has like a normal lot would that has frontage on the street. It's going to have to be about 25 feet in that end. So they do need a little bit of area for a driveway. I realize, Mr. Froer, I don't think you were here last time, and I can fill you in. So I'll show you the subdivision plat that shows the owner is proposing to build within what's called the buildable area on their plat. What happened was about I want to say it was a year or two after the subdivision plat recorded, the county adopted these stream corridor setback standards. And so even though they're proposing to build in their buildable area, they still also have to meet the stream setback area. Here's that plat that shows that 50-foot stream setback. So the request is still to keep it 50 feet, which would still be a 25-foot variance. The applicant has submitted a few other some images, and I imagine that they'd want to go through those more with you than I would. They submitted here showing that the elevation of this lot is significantly higher than the stream. He's saying about 15 feet. And what we're looking at here is the lot to the from the west. So in this image, it's facing east. Just kind of going through the staff report with you, show the floor plan of the home, which is about, I know you told me 2,246 square feet.
Steve, we may want to not have correspondence with the audience because it won't be included in the minutes. So if the applicant chair is willing to let someone from the audience speak, then we need that individual to come up to the podium and state their name for the record.
Sure. Another thing I'll mention is I received a call from the Wolf Creek Water District earlier this week. I think it was, I'm guessing it was at the request of the applicant, but the gentleman, the manager over at Wolf Creek Water and Sewer, his name is Rob Thomas. He informed me that the stream behind this house, although the county does recognize it as a year-round stream, and in this specific location, it doesn't flow year-round. And the reason for that is because Wolf Creek Water actually diverts that water to be used for secondary. So I just wanted to point out a few of those things to you. And then the staff recommendation is going to be that a variance can be approved if you as the board decide that all the variance criteria are met. And I'll show you those criteria. So it's A, B, C, D, and E. I'll just go over them with you. A. Okay, the Board of Adjustment may grant a variance only if the following 5 criteria are met. A. Literal enforcement of the ordinance would cause an unreasonable hardship for the applicant that is not necessary to carry out the general purpose of the Land Use Code. B. There are special circumstances attached to the property that do not generally apply to other properties in the same zone. C. Granting the variance is essential to the enjoyment of a substantial property right possessed by other property in the same zone. D. The variance will not substantially affect the general plan and will not be contrary to the public interest. And E. The spirit of the land use ordinance is observed and substantial justice done. I'll answer any questions if you have any. Otherwise, I know that the applicant would like to have a presentation as well.
From staff?
Steve, just a question. On the plat that show Exhibit C, that shows all of the lots in there, 1 through 8, it appears that several of those have shared driveways. Have you observed that as well? I don't know. I had to do otherwise. Let's do this thing. Page 13 in our.
Yeah, any
Right
lot that fronts along. Oh, okay, right here.
Yes.
Yeah.
So it appears several of those lots have shared driveways with one another, including 5 and 6 right next door share the same driveway as well. Are all of these lots considered, and Rick, I don't know if we can defer to you, are these restricted lots? Do they have an R with them that was restricted due to the nature? I can't see that they are. I don't believe any of them have restrictions on them. They just have the buildable pads identified on here, but you are correct. There are shared driveways associated with several of the lots in this area. So one could determine that this is not just unique to that one, but it's actually common with the entire subdivision.
Sure.
1 through 8 or 7. I know you moved the footprint, or with the applicant, the footprint's been moved a little bit, and yet we're still at 50 feet, but we're drawing it showing 55. Is that because of that patio? And is that patio cantilevered, or does it have a footprint going down to the ground?
So the building itself is 55 feet, but we also have to consider a patio when we're talking about the stream corridor setback. And so the image that I showed is 55 feet to the foundation wall,
Yeah.
but the patio itself is right at 50 feet.
Rick, is that correct? Because I thought if a part of a home was cantilevered, that it did not count if it encroached into that protection zone.
Technically, sometimes the HOA does allow for cantilevers to occur, but most of the time it's all supposed to be taken into that footprint area.
And the patio, it's my understanding that it's not cantilevered. It's just a on the ground patio.
So does it have any structure with the patio, or is it just, it's not just cement, it's got some structure to it as well?
I'll let the applicant answer that. I'm not as familiar with the building plans as he is, if that's okay.
So before you change, Steve, go back to the page 13. There. So looking at the lot 7, how far into the corridor? Yeah, how far into the corridor will this home sit based on the current?
So I believe the first image I showed you kind of point that out. So the corridor as that actually runs along this right here. This is the buildable area. And so according to this, the patio will be right at 50 and the house itself will be 55 feet back.
And the rule is 75, is that right?
The stream corridor setback is 75 feet. Yeah, for any parking or any structure, that's correct.
And the elevation from the high water mark in the stream is 15 feet.
The applicant stated that it's below. I don't actually know what the difference in elevation is. But the applicant in their revised submittal has said that the stream is actually 15 feet below the house.
In elevation.
That's correct.
Well, the last meeting we talked about rotating the home a little bit. Did we talk about that at all?
Sorry?
We could rotate the home a little bit so that it would be more even with the street, and then it would pull it up a little bit closer as well.
I don't. It doesn't appear to have been rotated, but that you're right. That was discussed. But it appears that the building is really just moved up a little bit farther to the north.
So we didn't try that at all.
I didn't know. It'll be up to the applicant to do that.
Steve, when did the applicant present this plan to the county? How long has this been?
I don't know. I couldn't say. I can find a. How long have they? How long has their application been submitted to us?
Yeah, is this just this year?
Yeah.
Okay.
Let me- I don't know how to get rid of this bar here. The variance application was submitted. Actually, it was accepted into our office on June 14th.
And the stream corridor setback was passed by the, approved by the county in 2003, 2004, do you remember, Rick? I don't know the exact date, but I know that this subdivision was approved, the buildable area and the plat was approved before that, and the stream corridor came into effect after.
So had they been built at the time that it was recorded, they would just be non-conforming and be fine.
Correct, for the minutes.
Questions for staff? Okay, let's hear from the applicant.
Good afternoon, board members. My name is Darren Hammond. I'm an attorney from Smith Knowles with Scott Bracken, the applicant. I just wanted to go over a couple of things, but also, if it would be all right with you, I would turn over back to him some of these factual questions that you've asked. But I think it's important for me to address some of the legal issues, which Steve very well presented to you. It's very important, I understand, for you in the position of being on this board, not to grant variances just haphazardly, and you need to follow the standards that are set forth in this ordinance. That they follow these 5 different criteria, because that's what Utah case law is. Utah case law is very concerned to enforce these kinds of situations carefully so that variances just aren't given all the time. But here we have compliance, because literal enforcement of this ordinance would cause an unreasonable hardship on this homeowner, on this lot owner, because of the way the property is situated. You'll see, I don't know that I can control this, but this page that we're on, this line of the lot is 100 feet. And to expect that somehow just a few yards below that we'd have a 75-foot setback is unreasonable. And when the it's already been pointed out a couple of times that when this lot was approved by the county, the 75-foot issue wasn't in place. It was a 50-foot issue, and that's what was on the plat when Mr. Bracken went to buy this lot. And when he went to buy it, he wasn't aware of this 75-foot issue. But that being said, this is not a self-imposed hardship at all. This is something that happened because of the shape of the lot, because of the timing of the lot being approved by the county before the 75-foot rule was put into place. And so we think that he meets A of this of the requirements. B is there are special circumstances attached to the property that do not generally apply to other properties in the same zone. Well, that is true because here we have a lot that was intended by the county to be buildable. There's a buildable area that's been identified on that lot, and I just don't see any other way to situate this home, even if it's rotated somehow, because then we've got problems with the driveway, we've got problems with UDOT on the other side with the road that's there, and so we have to be 25 feet away from the road. And so the way the driveway is, this is just the best way to situate this home, and it's not an overly large home with the footprint being 60 by 40 approximately. So I believe that B of the 5 criteria is met. The third criteria, C, granting the variance is essential to enjoyment of a substantial property right possessed by other properties in the same zone. This is quite a bit overlapping with the other one, simply because if we don't allow this property, this home to be built there, then that right to build a home won't be enjoyed as similar properties in the zone. D, the variance will not substantially affect the general plan and not be contrary to the purpose, to the public interest, excuse me. And so I do feel like the general plan is followed here, and that the public interest is not affected. He's still allowing 50 feet to be the distance between the home and the stream corridor. And then the final one, E, is the spirit of the land use ordinance is observed. I think when you take the fact that we have the 15 feet elevation and you have the 50 feet distance, that Mr. Bracken is doing the very best that he can in order to comply with everything possible and be able to live by the spirit of the rule that they've intended. We do want to protect the stream, but given these circumstances, I don't think that there's any other way to resolve this other than to grant the requested variance. So those are my comments on the legal issues. And in terms of, I would ask Mr. Bracken to address factual issues. Do you have any questions for me on the legal issues?
Thank you. Any questions? Word?
Thank you.
Thank you.
Good afternoon, Scott Bracken. Just to let you know, let's see. First of all, when that first plan was first drawn, just to kind of get back to your question on orientation, the intent was just to bring it in and be able to still have the setback to meet the needs of not only the UDOT, but like say within the guidelines or the buildable area. My request, I went to UDOT trying to get approved. The subdivision is all set to common driveway. That's correct. But I tried to go through UDOT to get a variant, or to get them to allow me to do like all other 40 homes along that stretch to get just a driveway right off of SR 158. One of the reasons was because off the corner of my lot, my brother's home is just next door, and so him and I now must share a driveway from UDOT. The other thing that was unique to the situation, not trying to get away from that common driveway, is just on that corner of my brother's lot, there's two Rocky Mountain Power went and put 2 big old power plants right there in front. So he actually has to not only he can't come into straight into his property, but he comes about halfway across. I presented pictures and whatnot showing the diversion across his lot and then across the stream and whatnot. So, Steve, can you get that? Can you bring up the new update?
So this one we're looking at was the previous submittal,
That was
right?
the original, yeah. And once that was drawn by the architect, and we started to measure that out, there was another, when we look at the overall subdivision, where my brother's house situated, we set the house too close. We could share front doors almost, it's that close. So it was originally set, the draftsman had to set it 6 feet just off the boundary line. That's too close. So now what happened where I got rejected by UDOT, have to use the common driveway. That driveway is now coming in across my brother's lot, across the culvert. There is another stream of water that just is an open area just on the right side of the driveway there. It goes underground and then goes up the canyon. That is also another irrigation water source. So based on that, I pulled it over as close as I could to the road, but still utilizing the culvert that he installed, making a common driveway, still staying within the buildable area, still giving the 25-foot front setback, but it's still allowing just, you know, in at least the far garage, minimum amount of space to get in that garage. So to cut back in anywhere else, you know, I would have to go outside the boundaries of the buildable area forward, which would not make it feasible. By the time we do that, and we drew it that way just to see if kind of played around with the measurements and whatnot, it would actually make it look like a parking lot coming right off I saw 158, which of course you got a parking lot.
Bracken, yes.
Yes.
Can you scroll down to page 7 of 24?
This one.
Go to keep going.
Oh, I can't see it. Oh, I'm sorry.
4. Right there. Go past it. Right. One more. There. So stop there. So the home that's obviously under construction, is that your brother's home? It's circled.
Completely finished. You see where we're at. And you can see right where the east face house, you can see those green boxes and across the road is also.
Can you speak more into the microphone?
Pardon me?
Can you speak more into the microphone?
Oh, I'm sorry. Yeah. Yeah, those green boxes, you can see where those are positioned and where he had to personally deal with those. And of course, now we both do based on the common driveway concept. So that's the reason for the orientation of the house, is to better access the house and the garages.
So the question I asked Steve was about the elevation change, this stream bottom to where your house would sit.
Correct. So there's 15 feet at the high water mark to the top of my lot. And then there's from the high water mark horizontally, there's 50 feet to that area.
So I want to say back to you what I think you said. High water mark on the stream,
Vertical,
vertical 15
15
feet
feet.
to the low part of your home.
Right.
And one of the things that Mr. Hammond indicated, I want to make sure the requirement is 25 feet from the road to your home. Again, based on the diagram here, is that what we have to deal with?
Correct. The other thing, if I could mention, when doing my due diligence and purchasing the land, I've been a real estate broker for 30 years, so I'm used to a lot of this stuff. But pulling up things like county records, abstracts, looking for anything through the abstract that would kind of poke you in the eye or bring in interest to. So I checked into everything before the purchase, just to make sure that I was safe to build based on what the county had shown. The other thing I did, and I won't mention names, I did call in the planning commission. I wanted to know if they had seen anything personally that would be affect this home being built. And the answer is no at the time. But so my question is, where would I have known that if I had known, or if that would have been changed back during the time of showing that 75-foot back? That makes that lot non-buildable. It gives you like a 15-foot deep home. It's not feasible at all. But there was nothing that indicated that. Otherwise, I wouldn't have purchased that.
Do you know how often the stream flows? Is it just
Yes.
runoff?
Yes. It flows generally. It has to flow between October and January. This year, it's been shut off now for 2 months because of drought. It's really dry. They generally, typically on a normal season, if I remember right, I sent all this information on Frontier from the Wolf Creek Irrigation Company. They generally shut off from July to October. So my point being on that, just with gathering that information is the ordinance states full-time streams or year-round streams. This is not a year-round stream.
So is it just fed by snow runoff?
Pardon me?
Is it just fed by snow runoff?
Yes.
Basically, that's what
Yes.
the source is.
Yes.
Mr. Bracken, when did you purchase this lot?
What, in May?
Just of this year, of 21? And you're saying when you approached the county, the stream setback never came up to you in any fashion?
Never. I would have purchased it if that was the case.
And also, you're stating that the stream doesn't flow year-round, but have you approached engineering on this? Because they're the ones that designate and have designated the year-round streams.
As far as I knew on Frontier, it looked like it had been approved by engineering. I haven't approached engineering, but I've spoke with people who control the water up there. And I sent in a letter from them, from both Wolf Creek Sewer and Water, which they don't control the water, but they had called Steve to let him know how the stream runs on a yearly basis, and then I also contacted the irrigation company who also supplied a letter stating, and that was also uploaded into Frontier.
So I know you made a statement that the home. I wish we had minutes from the last meeting because there were some things mentioned that Mr. Floor is not available to look at. But you mentioned that you wouldn't be able to build, but as a truer statement, you wouldn't be able to build this home on that lot. I'm sitting here with my finger moving and thinking, well, maybe not quite that big, but it looks like a home could be built on that lot.
It would be a very unique home, let's put it that way. It would be very narrow and probably unacceptable by the HOA. Yeah, you could probably build anything there. It's going to look like a shed. It's after you take that 25 feet away.
Does the HOA up there have certain standards to building size?
They do. They have to.
So
Of course, they look at everything, and I don't know what they're. If you're looking for a minimum, is that what you're looking for?
Well, I'm just wondering if you have to build a home a certain size, then reducing this really wouldn't be something that you could do.
But you don't know what that is.
I don't know what that is, but I have no intentions. I just moved from a small home, or I go backwards.
This plat looks like that lot is 0.6 of an acre before you take everything out. Is that correct?
That's correct.
And then also describe the patio. What's the patio like?
It's just a concrete patio, but there is a deck above. And the deck does have an overhang, so that still meets.
I think you've got a cantilever deck above the patio.
Yes. So that's one of the reasons I think that I was originally told the home could be with cantilevers and all. Originally was told the foundation had to be 50 feet, but come to find out it has to be a cantilever patio wall. I don't know if you want to bring that up, Steve, or not, but it just shows it on one of the other elevation plans.
Questions of the applicant?
Right. It's the side, yeah, it's the south. There you go. You see how the patio's built out, and that's right over the deck. Right over the
Okay. Thank you. Just have to look at those 5 criteria and see if they're satisfied or
I
not.
just have I have 2 questions for Rick from planning, if you could address them, maybe even legal. Is there, I mean, Mr. Bracken is saying that there's nothing he would have been given to indicate the stream setback. I don't understand how that is possible.
So typically when an applicant comes in over the counter, we look at generalities, but we don't get into all the specific details until something's actually submitted into our office. We just don't have the time or the manpower to go through everything and catch everything. And so when something's submitted, that's when we look at that, and that's when this was caught. So sometimes that information is available, but it's on the applicant to do the due diligence on going through the ordinances on that. But we try to give them as much information as possible that we can see at the time.
And I agree with what you're saying. Is that stream setback published somewhere? I mean, if I
Yeah.
buy a lot, I can easily find that, or I should be able to.
It's fairly easy to find, but not what may be easy for us may not be easy for someone else. But yeah, it's right out there on the planning side. So you can pull that information up.
Does planning share the opinion that this is a non-buildable lot if this is not granted?
Are you asking for a recommendation from staff? You've asked us not to get into that.
No, not a recommendation of approval. But
Okay.
No, I'm just saying, do you agree with the applicant that this would be a non-buildable lot if the variance wasn't granted?
I wouldn't say it's a non-buildable lot, but it would be more restricted. When you look at the configuration of this lot compared to the other lots in the area, it does neck down at the north side of it, which does provide some constraints that other lots in that area don't have.
It's a unique lot.
Yes.
It's not only got a lot of smaller size, the shape of the small, the buildable area is smaller.
Yeah, it is. Yeah. And it is unique in the sense that it is smaller, but also where it does neck down in through there, you have a corner lot. And so basically on a corner lot, you have 2 front yard setbacks, which is unique in that sense compared to other lots in the area.
What's unique in regards to this lot, but it's not something, if I'm buying this lot, I'm going to be aware that there's those setbacks, restrictions. I may not be aware of the full stream setback, but even with that stream setback, that footprint's not real large.
Yeah, correct.
The other thing, the actual stream setback, is it engineering that determines year-round stream versus seasonal?
Typically, we look at engineering for that, but you may recall that you gave us some guidance a while back to possibly look at some alteration to that stream setback corridor, and that's something we are looking into.
Does the Army Corps of Engineers regulate these streams at all, or is it just?
Yeah, we do work with the Army Corps of Engineers in determining that. But
Unless it's navigable, I don't think the Corps of Engineers has any jurisdiction.
usually not. Usually that's something our engineering division looks at, and we rely on them for that.
I think this was probably something you addressed last meeting, but it would appear that all 3 homes that are on the page 7 of 24 are much closer than 75 feet in terms of a setback from that stream.
That's correct.
And that was just because a variance was granted previously. Is that?
I believe there were some variances granted up in that area, and whether those, and there may be some homes that were built prior to the ordinance. I don't have that exact information at hand at this time. Yeah, I think we can discuss this. So one discussion point just as a board, but I think we touched upon a little bit, and that is as another alternative, whoever determined that this was a year-round stream, that could be possibly appealed to that entity. Courtney, do you have any, I don't know who they would talk to. Is it engineering? Yeah, I believe it's our engineering division that they would work through, and then we would have to designate it as something else, as a seasonal stream versus year-round. Right.
And with that happening, what would the setback then become?
Steve, do you know right offhand on seasonal?
Seasonal's 50 foot.
That sounds right, but I want to make sure. Steve,
Yeah.
sorry.
So I've talked to our engineers last week about this specific application, and I asked them the question: would you be willing to designate this stream as a seasonal stream since it doesn't flow year round? And they told me no, they wouldn't be comfortable doing that. They said they're okay with the 50-foot setback, but for whatever reason, they still want this to be designated as a 75-foot setback.
Can you explain that?
I can't. I didn't get the reasoning why. They said we want it to be a 75. I know that there are portions of this stream that likely are flowing year round, and perhaps that's why. But no, I don't really have a good reasoning as to why. Somebody could change the map. It would probably look something like a county text amendment. To change the language of the map, and also the map is actually part of our ordinance, so they'd have to change, where those little blue lines run through. So they potentially could change the law.
So if this stream wasn't diverted, it would be a year-round stream.
Correct.
Is the opinion of engineering?
Yeah.
So it might depend on how much snow we have a particular year. Like now, because we're in drought, there's no water at all, but there might be other years that we have tons of snow that it would be not all diverted.
I don't actually know. I just what I do know is that there is a group that diverts from this stream, and when they do that, occasionally, the stream just dries up.
Okay. On our findings, we just need to find the interior. Lot, buildable area.
I don't question. I think there's definitely some special circumstances, but going up a little bit, literal enforcement of this land use code, which is the stream setback, would cause an unreasonable hardship. While it seems that it's causing a hardship for the applicant, for Mr. Bracken, it's, to me, it's partly a hardship because of the size of home and the configuration of the home, and without knowing what the Well, plus, and you had even mentioned last time that, you know, reconfiguring the layout, which seems to be still configured the same. And it may not work because of that house, but just to a small extent, I still feel there's a self-imposed hardship here. And also, when any of us buy a piece of property, there's a due diligence. And it sounds like from the planning director, while they're not going to be able to cite every circumstance, it is out there for reviewing. If that's fair to say. This is a hard one in several ways.
Somebody could call the planning office and just ask what the hardship, what the setbacks are, but they don't notice that their setback with their, think about that. So last time we talked about whether there's a property right, the essential property right is being taken away. Maybe not this one. So, and last time we talked a little bit about the layout of the home was to protect its view, and the view is not.
At least we don't grant variances based on
Right. Because there are other there that setback that the spirit of the land use code would be observed if you granted it. I think there's some of these we can find. I agree. I think we can get granted on some of these. I'm not sure if we can grant it on. Just to play off of.
And the purpose of the stream setback is riparian related.
It is to protect the riparian area and the watershed as water flows in that area. So, and it's also protect homes as well. And where our engineering division typically rely on them, and where they gave some input too, that's something you could consider.
Do we know why the standard 75 feet?
What was that, Chair?
Do we know why the standard that was established by ordinance was 75 feet?
We could go back and research why the 75 feet. I don't know exactly the hard and fast rule for the 75 feet, but obviously there is some reasoning for that.
Steve, can I ask you another question? Along the lines of the engineering discussion, is there a reason that engineering said we're okay with this particular variance, but we still want to require in other situations the 75 feet? Did it have to do with the elevation change? Was there an explanation they provided at all?
There wasn't an explanation. No, I can, if it's helpful, this is what I'm showing on my screen now is what's called Frontier. That's where all the projects are reviewed by the county, and it's all public record. When I go to this application, this Board of Adjustment application, our engineering office uploaded a review and simply said they have no concerns with this project. They're not providing much of a reason why.
Can you go back, Steve? Go back.
Would it also be helpful to review their comments on the building permit, which was a separate application?
Sure.
The building permit hasn't been issued, has it?
No, it's just been applied for. And say we probably wouldn't be here.
Well, it would be kind of after the fact.
We actually have a few reviews coming in from our engineer's office.
On that last page, I saw several not approves.
It's let me show you.
Right here. Engineering review number 3 not approved, 2 not approved.
Yeah, 1, 2, 3 not approved. I'll go to their first comments, which were culvert, so not related. Excavation permit, not related. Geologic site reconnaissance, not related. Stormwater construction, not related. Stormwater pollution, not related. They don't actually say anything about the stream. Let me go back to the other reviews. Still are asking for the same things in the last one. Still not referencing the stream. Still stormwater and access. Nothing about the stream. And then their fourth review, they approved it. So they didn't even call out the stream.
So, Steve, engineer, it doesn't look like engineering approves or unapproves stream setbacks. That's planning.
Engineering, the county engineer determines the high water mark. So yes, they do. They do look at those.
But as far as the 50 versus 75, are they the ones that catch that?
We both do. It's planning and engineering, yeah.
But this isn't a land use code, so it would be enforced by planning more than anyone else, right?
There's a way to look at it that way. Yeah.
In the past, what's happened is when we do find that information, we go directly to engineering and consult with them and get their feedback. And that's what we've historically done. Just FYI.
Chair, I'd like to propose a motion.
Okay.
I would move that we approve BOA 2021-08 consideration and action for a request for a 25-foot variance to the 75-foot stream corridor setback for lot 7 of Hidden Oaks, Wolf Creek, subject to the conditions and requirements that have been outlined and addressed today, and also based on the representations that engineering had no objection to the proposal.
Do you want to list, identify the findings that it meets the 5 criteria?
I would incorporate the findings on page 2 of 24 that suggest or encourage the approval of the variance. The literal enforcement would cause an unreasonable hardship. Special circumstances exist that are unusual to the lot configuration. Granting the variance would allow the owner to increase the distance of the home and driveway from Powder Mountain Road. 50-foot setback depicted in the plat for lot 7 of Hidden Oaks met the standards at the time of its creation, and this variance is not an attempt to avoid or circumvent the requirements of the county land use code.
Thank you. Do you have a second? I can second that, right? I'll second it.
Can we discuss more?
All in favor, oh, do we have discussion on the motion?
Have discussion.
Rick, are you aware of this discussion with engineering
Which discussion are you referring
that
to?
Steve's mentioning that they won't change the 75-foot back setback, but they're okay with 50. I do not understand that.
I am not aware of that discussion. I mean, I haven't been in discussion with them on that, but I know that that has happened in the past. So it's not like we're setting precedents here. But I can come back and get information and come back with that to you, but I don't have that at this current time.
And I think in this instance where the stream is down lower than the property, I think it's not really as much of an issue.
And maybe that's one reason why engineering was looking at that, because as the applicant's indicated, there is a 15-foot distance between the high water mark and the low portion of the home. So maybe that had something to do with it, but I don't know for sure without consulting with engineering.
Because I think that is a good point. Engineers are going to look at the safety and what the stability of the home would be. I'm not sure they look at the riparian habitat or that element of it as much.
I wouldn't say as much, but they are somewhat concerned about that. But that's why it's in our land use code, because planners have a tendency to be a little bit more sensitive to those type of things. That's kind of additional on our engineers because
Yeah. Well, they're not here. So where I'm struggling still with this, I'm just sharing this with these two because it takes all three of us to pass this, and I'm struggling. We asked the applicant to come back with some possible proposals. If he'd have come back and said, geez, I've changed this and I can take a 20-foot variance, a 23-foot variance. I mean, we met and discussed this thing and there's absolutely no change. And that's a concern, or a little bit of a frustration on my end. And I know Mr. Furr wasn't here last time, but we spent a lot of time trying to look at this
What's different with this one than the previous
than
one?
the last one that we tabled. Because frankly, we tabled it so that he wouldn't have to come back with a new application. But with absolutely no change, I'm not very encouraged with where we're at on this. And I still feel like a lot that was purchased in 2021, when this ordinance was passed in 2004 or 5 or somewhere in there, there was certainly some due diligence that was missed. And I'm not faulting Mr. Bracken per se, but I think we all have a due diligence to look at there. So I'm still struggling with this. I probably am not in favor of it, but we can call for a vote.
Okay. All in favor, say aye. Aye. Opposed?
Okay.
Okay. So it's 2-1. This board requires not unanimous, but when there's only 3 of us, requires all 3 to vote the same. If we had 5 of us here, 3 would work, but we've got to have our rules require all 3. Is that correct?
that is correct. This is how the rules of order state. Going on my glasses, but it says 3 or more members shall constitute a quorum for the transaction of business and the taking of official action. However, in the case only 3 members in attendance, a unanimous vote shall be required to approve or deny an application.
So where it's not approved now, what happens? It's not denied either, or what?
It's
It
denied.
would
We need to make a
constitute a
motion for
denial.
that.
Based upon the motion, it would constitute a denial.
And just for the record, I would state that I feel the applicant did not come back with what he was asked to try to do, and that's lessen this variance at least. We're basically getting the same And to that extent, I think there's still a self-imposed hardship that is a part of this.
Thank you. So work with staff, see what else we can figure out. Nice. This point. So is there any other business before the board?
Second. I have one item that maybe I could just bring up. If typically the planning commissioners go to the Utah APA conference, but if any of you board members would like to go to that as well, we can send that information out to you, and you can go to any of those trainings. It's a couple of days. I believe it's in September. I can get you the exact dates, but I believe it's a Thursday and a Friday. I think it's the second week in September. But if you're interested, you want me to send some information out to you?
And it's in Taylorsville this year?
Yep. So I'll send it out, and then just reply back to Ann. And if you want to go, we'll pay for your registration.
Okay. Thank you. And then we talked about the annual dinner at one point.
Yeah, yes, we did. So that one we were going to wait until fall for that, but as we talked to the other planning commissioners, where typically we have the annual dinner in January, just wait a couple months and we'll just do it then. So that's where we're at on that. So unfortunately, and hopefully everything will be good.
We can do it I'll live in person.
Yes, exactly.
So we have a motion to adjourn. All in favor, say aye. Aye.
Back to them.